I'm not
But
going to
Your
decide
Honor,
the custody case before I decide whether I have jurisdiction to do so.
Your Honor, I might not have been able to prove it because I don't have an attorney. That there has been reprehensible.
Requesting a change in jurisdiction because the judge at that time said that I had to file it as a separate motion.
2 states, 1 family, and a custody battle tangled in jurisdictional chaos. California issued the move-away order, Kansas claims home state authority, and neither parent agrees on what the orders even say. This case isn't about custody yet. It's about who gets to decide. Subscribe, like, and share for more courtroom drama.
In the matter of the marriage of Benjamin H. Bravo and Monica O'Rourke Bravo, it's case number 2024 DM 309. Each party, Benjamin and Monica, appear by separate Zoom. Court conducted proceedings in this case on February the 12th. The court had a rather extensive set of docket notes, which I'll just read. At that time, Monica and Benjamin both appeared by Zoom, Benjamin from California. No action was taken on Monica's parenting time motion. Court notes that the registration of foreign judgment was not timely opposed. The Kansas court has not made a decision as to whether Kansas accepts child custody jurisdiction to modify custody or parenting time orders. There's a California hearing. Judge Hamilton, Division 303, Fresno, California, set for March 18th, likely to be postponed on Dad's motion to have primary residential custody. For now, California maintains jurisdiction. Court order temporary to be provided to court for consideration and possible UCCJEA conference and determination. Kids have lived here with mother since November of 2023. There's a move-away order granted in California in September of 2023. Kids apparently in Andover schools. Her California restraining order expired, and the review hearing was set for today. All right. After all that, we are where we are. I'm curious, what happened in California during the scheduled court proceedings for March 18? Monica?
Your Honor, there was an ex parte hearing in at the beginning of March to request an extension for the trial in order for my lawyer to properly subpoena witnesses, since all of the witnesses for this case are in Kansas and require a little bit of extended time to get all of the subpoenas together for that. In light of that request, the judge postponed the trial or continued the trial to May 28th and 29th. There's 2 days, 2 whole afternoons set for the trial and on May 28th and 29th.
All right, Benjamin, is that your understanding as to what happened?
I wasn't present for the hearing, but there is a court date set for May, I think those 2 days right there. So.
All right. Monica, are you comfortable with the California court retaining jurisdiction and making the determination regarding any issues which may exist?
Your Honor, there's currently a motion and temporary order, which is what the California court is hearing in May. It is my understanding that because that order has already been, because it is already in process in the courts in California, that it's required that they finish this process for this current motion. If that is not the case, my preference would be to move the jurisdiction to Kansas immediately. If that is the case, that the current motion needs to be decided on in California first, then I would like to have the jurisdiction moved to Kansas following the conclusion of that motion.
Well, at that point, that could possibly change the physical custody of these children from Kansas to California, couldn't it?
Your Honor, that's actually not what the current conversation is regarding. The kids currently, I still retain, so let me back up. There was a temporary order put in place in January And that in question at the hearing in May is whether or not that temporary order will become permanent, not a change to that, not necessarily a change to that order. Currently, the temporary order is that I still retain sole legal custody. We have shared physical, in which case the children's primary residence remains in Kansas, and Mr. Hernandez has visitation. It was simply just an increase in the amount of visitation, not
That's
that
not, that's not the
there's
situation, Your
Okay,
Honor.
let her finish, Benjamin, because I'm going to address you in just a moment.
Okay.
Go ahead.
The current order does state that the children's continued residence is in Kansas, and that the order is for them to fly to California 12 times a year, spending 71 days there. There's a lot of question around how it's written, and this is a big part of why I'm asking for the jurisdiction to be moved to Kansas, because the California judge wrote the orders in such a way that is very incongruent with Kansas laws and Kansas school districts and this Kansas school calendar. So the order will have to be changed in some way. It's incongruent and not reasonable to follow the way it's written, because it is written from a California court based on California schools, even though the kids are permanently residing here.
All right, Benjamin, thank you for your patience. What is your understanding of what's
The-
going to be contested?
So when I filed the paperwork, the boys were being homeschooled, and so the court order, that's the temporary order that's in place right now, it has us exchanging every month. So I have the odd months and she has the even months, and so we split like summer times and spring break. That's in the plan as well. And I think they did that because they were in homeschool when I submitted the paperwork. And so this last year, Mr. O'Rourke decided to change up the school situation so that she could attempt to continue to maintain that custody. And so one of my boys is in permanent school now, and the other one's still doing temporary. He's doing homeschooling, the other one. So that's why both of my boys have been homeschooled most of their lives. So that's why the court order was issued in such a manner, because they haven't been around me the last few years like they were before. And so the court addressed that issue because they have been homeschooled. And so they were trying to give each one of us 50-50 physical custody so that we could both be present in their lives. And that's why the order is written the way it is.
I'm sorry, Your Honor. I'd like to clarify some of the inaccuracies that were just stated. The children were not in homeschool when the motion was originally filed. The children were enrolled, pre-enrolled in Andover schools back in May, and this motion was not filed until July. I'd also like to take your attention to the current order that Your Honor has a copy of. I sent it during our last hearing. Under the order 3.02 states, commencing with the date of the signing of this court order, the children shall reside primarily with the mother in Butler County, Kansas, except for the specific periods of time outlined below. And every other month order that Mr. Hernandez is speaking of is that he is to see them for one weekend every other month.
That is not correct.
There are additional inclusions in that order for them to spend time over holidays and during the summer as well, usually in a 1 week increment. But point number 3.02 does clearly state that commencing with the children's primary residence is still maintained in Butler County, Kansas. In which case, I am currently asking for Your Honor to request jurisdiction be moved to Butler County, Kansas, since these children will, regardless of the outcome, this is the current order in place right now. The hearing is to contest that. The hearing coming up in May is to contest this order. I am the one contesting it. I'm not contesting that their residents continue to be in Kansas. I am contesting the amount of time and the methods that visitation continues. I do believe it is important for the kids to continue to visit their dad. It's my contesting of it is simply that they, like I said before, the way that the order is written is very incongruent with Kansas, the way the structures are here in Kansas. And that is my only request. And so if it is possible to have the entire motion move to Kansas and have your honor hear this order be contested here, that would be fine with me. And if that's not possible, then let the California court finish this portion and then have it moved here, because the judge has already ordered that the kids' residence has been and will continue to be Kansas.
That's not the situation. I'm not really sure what order Miss O'Rourke is reading, because that's not the court order that was granted. Because there's a 3-phase process to that new order, and I just completed the 3rd phase by visiting my sons in March of this month, and I'm supposed to get them every other month. So they gave us both 50-50 physical custody of our sons. I'm not really sure which order Miss O'Rourke is reading from, because that's definitely not the wording that I'm reading in the order at all. And this is one of the reasons why I think the Kansas court should not take this case over, because Miss O'Rourke has now been willing to co-parent every single situation that she can figure out to put up to make a wall between me and my kids. This is just another situation. By transferring over to Kansas, she's able to maintain that control, which she really likes. And she's able to put up just another barrier in between my relationship with my sons. I've completed what the court has asked me to do, and I'm asking the Kansas court to not take take jurisdiction of this case, because I feel like Ms. O'Rourke is just putting another barrier between me and my sons, and this would not be good for Ben or for Sam. They want to be around their father. They've specifically made that clear, and I hope that the Kansas court will understand that I have been present, and I will continue to be present, and I hope that the Kansas court understands that they need their father. That I'm just as important as the mom in this situation. If you see me and my kids interact with each other, you will see a completely different story than what Ms. O'Rourke has shared in the court hearings. She's been able to get away with legal maneuvering through the legal system to put up, to basically legally harass me in my parenting ability. And I'm asking the Kansas court not to take this situation over, because what she just read, that she said that there's 12 weeks, I believe she said, 12 weekends that I get to visit. That is nowhere in any of that paperwork. It says that I'm supposed to get them in May. She's supposed to get them in June. I'm supposed to get them in July. She's supposed to get them in August. I'm supposed to get them in September. We're supposed to split the holidays, the spring break, and the summertime. I'm not really sure which court order she's hearing or reading, because that's not the court order that I received from the Fresno County Court.
I have before me what's called a family law findings and order after hearing, apparently issued January 15 of 2025. It makes reference on page 2. Court will adopt the proposed custody and parenting time order as a temporary order until the contested hearing. See temporary order, child custody and parenting plan filed today's date. That is not attached to this order.
Right. I think
I
you
don't know
just
what
got the
it says.
minute hearings or the.
Your Honor, I already, I did send you that order the last time we met. I can resend it again if you'd like.
This temporary order, which is supposedly an attachment to the order that I have.
Correct.
Okay, well, I don't have that before me. Let's put it that way. So I don't know how to resolve the dispute between the two of you as to what that temporary order says. It is what it is. And I'm not going to advise the parties to go against it. All right. When did the children establish residency in Kansas?
In November of 2023.
Okay.
And Your Honor, I did just resend the actual orders of which I was referring to when I read 3.02. And the portions that Mr. Hernandez is referring to are below that. In that same section, the children established residency in Kansas in November of 2023.
This moment matters. The judge questions how California could still be the home state when the children lived in Kansas for over 6 months. That directly challenges the legal foundation of California's authority. Under UCCJEA rules, home state jurisdiction is everything. If that finding collapses, the entire case structure changes dramatically.
Okay. All right. November of 2023. And then Mr. Bravo Hernandez, you filed something in California to reinitiate proceedings there. Is that correct?
Right. Yeah, I've been in the process of
Do you know the date that you filed your motion?
I think it was like in June. I want to say June or May of last year.
Your Honor, it was in July, the end of July of 2024.
Okay. One thing that is somewhat disturbing from a child custody jurisdictional standpoint is the court's finding that was apparently made in January that California is the home state
Right.
in this case and continues to have jurisdiction.
Yes. They said
I
that.
failed to see that the facts supported that finding. I don't know how that finding was made. Kansas was apparently clearly the home state of the children as of not only January of 2025, that would have related back to sometime during the summer of 2024. Generally, there's a 6-month establishment of home state jurisdiction. If the children have lived continuously within a certain state for 6 months, that new state has child custody jurisdiction, what we call home state jurisdiction. And if there was no motion pending in California after the children had been in Kansas for 6 months, I don't quite see what the basis was for a finding that California was the home state, because it wasn't. The children weren't even living there.
I think we've been in legal proceedings since she moved away, to be honest with you. That's why the California jurisdiction they took effect.
Your Honor, that's not true.
I mean,
The final legal proceeding was the move away order when we moved out here in November of 2023. There were no pending legal proceedings until Mr. Hernandez filed the motion in July.
Okay. All right. I guess all I'm saying is I'm struggling with the concept that California is retaining jurisdiction as home state. Now, they may have some other basis for jurisdiction, but if they're relying on home state jurisdiction, I'm just not sure where that finding comes from.
Right.
And if that was the basis for jurisdiction, I'm not sure California has it. Kansas very well may. All right. Well, something that the California court has not contacted this court. This court has not initiated contact with Commissioner Hamilton pending the outcome of the March hearing. We now know what that was, and that was establishment of a trial date in May. I think this court is going to have to initiate contact with the California court. We're going to have to sort out this issue of child custody jurisdiction. Kansas law, and I'm quite confident California law would also support that there needs to be a conference between the two courts to determine who's going to take child custody jurisdiction over these children at this time?
Your Honor?
Yes,
Oh,
and I understand your position that you don't want Kansas to take it.
right.
I get the impression certainly that Monica doesn't want California to keep it. So
That's because it's in our best interest. But I was going to ask
It's
you,
actually in the best
can you
interest of the
clarify?
children to
Okay,
have
okay, just a minute.
custody.
Just a minute. I'm going to give Benjamin the floor. Benjamin?
Can you just clarify like what that court order allows me to do? Because I think one of the issues here is that we're not able to co-parent, and she is wanting to maintain control, and I just want to figure out what am I able to do in terms of seeing my kids, because that's really what I'm interested in. I'm not interested in dealing with Miss O'Rourke. I'm interested in just seeing my kids, and so I just want to make sure I maintain or understand what this court proceeding, what it allows me to do when it comes to seeing my kids.
Are you talking about Kansas or California?
No, the court order, that temporary order that was it was provided to us, because Mr. O'Rourke has a different interpretation of what it says, and in according to what I've read is that I can see my kids in May, so they have to be flown out to California, and that's what the court was telling us, that we have to pay half of the ticket for the kids to be flown out. Mr. O'Rourke keeps on asking me to pay for me to travel out to Kansas every single time. And so I just want to get clarification from somebody that's in a legal situation, so that I have a good understanding of what, the next time I'm able to see my kids.
All right. Well, I presume this order attachment, which I don't have before me, addresses that. As far as interpretation of it, I would suggest that your California lawyer interpret it for you.
Okay.
I'm not going to be giving either one of you legal advice as to what a California order says. There's no Kansas order which governs things right now.
Right.
That I can construe for you.
Okay.
But you're not proceeding under a Kansas order. You're currently proceeding under a California order.
Okay.
So I think I'll let your attorneys give you advice as to what your rights are or are not under this temporary order, which will be in effect at least until the end of May. Apparently, trial date, and that's great. But that also establishes the time frame for me to get with the California court, because I have a motion here in the Kansas court, which we really can't further as long as California is entering what could be conflicting orders.
Right.
And I don't want you two to be confused about what state's orders to follow. So we need to clarify that.
Right.
And that will be this court's next step. Apparently, it's at this point, it's unavoidable that a UCCJEA conference will be necessary between me and Commissioner Hamilton. And I trust Commissioner Hamilton's still going to be the judge that hears the case in California?
Yeah.
Okay. All right. I don't know how often they shift those cases around. I don't know how their system works, but if that commissioner's still staying with it, then that's who I'm going to need to contact.
Okay.
All right. I think I probably have accurate addresses and email addresses for the two of you.
Yes.
Probably
Okay.
so.
All right. Well, when there's an outcome of that conference, I think it's going to be necessary for you two to be notified exactly what that result was. And this court will likely have to take the responsibility of issuing just an order, either confirming or declining jurisdiction here in Kansas. I am curious how the California court thinks they have home state jurisdiction. There may be some facts there that I'm not aware of currently.
Your Honor, under all of the dictates of the UCCJEA, Kansas is the state that would be required to have jurisdiction. I created a motion in California because I thought I needed to create it there to have jurisdiction transferred. And they denied that motion without prejudice, telling me that I needed to have that proceeding started here. That being said, just so you're aware, Judge Hamilton does have documentation regarding this process or this proceeding that I have previously filed in California. So she should have in front of her the reasoning and for the change in jurisdiction to be in Kansas. And again, I do want to note that I did send you the temporary order that is currently in place. And when you look over that order, my primary concern, again, in the best interest of the children, is that it has them missing school for extended periods of time. It has them flying back and forth between Kansas and California multiple times a year. Just creates a very unstable situation for the children. And so what I'm asking the courts, what I will be asking the California court, if this motion continues in California, or if it's possible to have this motion heard here in Kansas, and abandon that trial to bring it here instead, and continue and have jurisdiction continued here so that the change in order could be heard here. Either way, the primary concern is that having a California court determine.
Now emotions collide with law. Father accuses mother of control and legal harassment, claiming barriers block his relationship with the children. The judge listens, but carefully separates emotional allegations from jurisdictional facts. No misconduct finding here. This court isn't judging parenting yet. It's deciding which court even has the power.
Custody scheduling, visitation scheduling, when the children's reality is here in Kansas, and it is very, very different. I was a teacher there, I was a teacher here, and they're very, very different places. Just in the best interest of the children to have long-term, we have 7 years left, but who's counting? But longer term, to have the Kansas jurisdiction so that it can be responsive to what their needs are as they develop and grow here.
Your Honor, can I say something?
You may.
Ms. O'Rourke pretty much has limited my amount of time that I can see the boys. But basically, her preference has always been that I be placed on supervised visits and that she have full custody. That's always been her preference. It's always been limited. This is basically another way of doing that, is creating all these hurdles so that she can maintain control. It's not really about looking out for the best interest. If she was looking out for the best interest of our boys, she would not have moved them to Kansas, because they don't have any family in that area. She doesn't have any family support. She didn't look out for the best interest of our boys when she made that decision to move them to Kansas. You attend a soccer game. I was there a few weeks ago to watch my boys play soccer. Basically, there's no one supporting them at these soccer games. If they were to be here in Fresno where they're supposed to be at, my entire family would have came out for the game. And that's like uncles, aunts, nephews, and nieces. They would have came out to support my sons. I don't think it's in the best interest of my sons to live in Kansas, but that decision was not made up to me. And I think in the long term, my boys, it would be more beneficial for my boys to be around me because that time has been limited the last few years. Their mom maintains control physically, legally, and psychologically. She has alienated those boys from their father, and she continues to alienate Ben and Sam just in her ways. For instance, the other day I was supposed to have communication with Ben and Sam on Zoom. I forgot. Instead of her getting a hold of me, she decided that she didn't have any responsibility to to communicate with me over talking parents. And so I sent her a message and I said, hey, I'm sorry I forgot to get on Zoom. I'm on Zoom now. Can you put the boys on? And I didn't hear any communication from her until like the following day. She didn't even respond to that message. Um, these are the types of things that happen quite frequently with Miss O'Rourke. She has pretty much limited my ability to communicate with them. The only thing that she allows me to do is to communicate through the court order, whatever has been granted, and that's not necessarily in the best interest of our sons. Our sons, if you see them with me, they want my attention. Like they want to communicate with me. They want to hang out. We play nothing but sports and enjoy our time together. Um, yeah, it's just been a big situation where Miss O'Rourke, she seems like she's doing it in the best interest. She communicates really well, but when it comes down to it, Miss O'Rourke is not doing what she's supposed to do as a mother. And me as a father, I don't think it's in the best interest of my sons to be away from their mother. I think they have that good relationship with her, but I don't think what Miss O'Rourke is doing in terms on the other side of not allowing me to communicate with them, not allowing me to see them, is in the best interest of our sons. And this might not be present now, but in the future, it's going to affect them psychologically. And Miss O'Rourke knows this because she's an educator, and she knows way better than what she's doing for those boys right now. And I hope that the Kansas court understands that this is more about control. This is not about actually looking out for the best interest of our sons. If she was looking out for the best interest of our sons, she would have never moved them out of Kansas.
Mr. Bravo Hernandez, do you think it's in the best interest of your boys to have their educational programs disrupted every other month by being sent to California and not being in school?
The thing about that is that they have been homeschooled most of their lives.
Okay, regardless of what the past was, isn't the current reality
Right.
they're for this last school year, they've been in a structured school situation?
I don't think that it should be they should be disrupted, like the educational flow of their program should not be disrupted. I don't think that's in the best interest of our sons, to be honest with you. But the other side of that is I don't think it's in the best interest of our sons to move them to another state, where they're going to be separated from their father. I was separated from my father at a very young age.
All right. I guess I'll stop you there, because if you're obviously we're not arguing custody of these boys today. That matter is not currently before this court. What is before this court is a possible issue as to whether this court should take over child custody jurisdiction and then hear this case.
Right.
With all of these factors being considered. If you're attempting to suggest to this court that Monica has engaged in reprehensible conduct that I should consider in declining of jurisdiction, nothing you've said in the view of this court constitutes reprehensible conduct. In fact, even the move away was done pursuant by court order in California. She sought proper permission from the court to move the children away. So I don't know that we've got a reprehensible conduct case here when it comes to whether or not Kansas should exercise jurisdiction. And I'm not going to decide the custody case before I decide whether I have jurisdiction to do so.
Your Honor, I might not have been able to prove it because I don't have an attorney that there has been reprehensible being dishonest in the court system. But in my opinion, the facts of the situation are a little bit deeper than this, and I know that you can't take it. You can only look at what's been judged on. But if you look deeper into the situation, there has been a lot of dishonesty in the situation to be able to maintain control, and this is what this case right now is currently about. Moving jurisdiction is just another control issue, and I don't think it's in the best interest of our sons, but that's not, I can only control what I can control.
Good. All right, the court will take the issue of Kansas child custody jurisdiction under advisement. It is the intention of this court to set up the conference with Commissioner Hamilton in California. We'll discuss the jurisdictional bases in California and Kansas and make an appropriate, hopefully, an appropriate joint determination as to what jurisdiction is the most appropriate forum to hear any child custody or parenting time schedule disputes which currently exist between the two of you. And obviously with the best interest of these boys in mind.
Right.
So I'm going to set this case for review hearing prior to the California trial date. So I would intend to notify you by written order what the outcome was with my jurisdictional meeting with the California judge prior to this time. I just want to make sure I have a date on the calendar to work towards. The date, 28th and 29th.
I'm double checking those dates for you. Sorry. I'm sorry. It was the 20, it is the 29th and 30th.
Oh, okay.
Yeah.
Right. I am looking at a date for review on Tuesday, May the 27th. I'll conduct it at 11 o'clock a.m. Kansas time. Which I think it'd be 9 o'clock in the morning in California, wouldn't it, Mr. Bravo?
Yeah, I had to do some adjustments this morning because I forgot you guys were two hours ahead.
Okay.
The 27th should work. You said the May 27th?
Yes, that's the Tuesday right after Memorial Day.
Yeah, that should work.
Okay. So it'll be 11 o'clock Kansas time on Tuesday, May the 27th. I think for simplicity purposes, we use the same Zoom numbers as last time, Mandy. Now that we've shifted to a different Zoom system, will we have to send another Zoom invite?
We can use the same one.
We can use the same one?
Yes, Judge.
Okay. It'll be the same Zoom numbers then. And we'll look at the case again based on then current circumstances, Tuesday, May 27, 11 o'clock a.m. by Zoom.
Thank you, Your Honor.
Until then, I hope that you two can work together in accord with the California orders in the best interest of your children.
All right.
Thank you, Your Honor.
Thank you, Your Honor.
We'll see you May 27th at 11 by
All
Zoom.
right, you too.
Benjamin H. Bravo and Monica O'Rourke Bravo. It's case number 2024 DM 309. There's no appearance from Benjamin Bravo. Monica O'Rourke Bravo does appear. Docket notes from our last court proceeding was from April the 2nd. Both parents appeared pro se by Zoom. The court noted California had set a trial for apparently this week. A UCCJEA conference was needed. Mother desires Kansas jurisdiction. Father wanted California jurisdiction. Court made no orders other than setting a Zoom status conference for essentially today at 11 o'clock. Court was likely to issue a written order following a UCCJEA conference with the California Commissioner. Subsequently, on May 21 of 2025, the court did conduct a Zoom conference with Judge D'Alessandro of the Fresno, California court. A decision was discussed regarding UCCJEA jurisdiction. In other words, who will decide child custody who will exercise child custody jurisdiction. California did not decline jurisdiction. California decided to keep the case for trial out there starting, I think, May 28th, which would be tomorrow. This court would issue a journal entry documenting this. This court did enter an order entitled Journal Entry of Determination of Child Custody Jurisdiction following communication between courts. And that was apparently dated and filed May 21st of 2025. Both parties were notified. Perhaps after receipt of that order, Mr. Bravo felt it wasn't necessary to appear this morning. I wish he would have. However, I think under the circumstances, I understand why he didn't. The real issue before the court right now is what does the court do with this Kansas case? California did not decline jurisdiction. They decided to exercise it at the trial to take place this week. I don't know if there's any real business for this court to conduct. Monica, you're on this meeting. What is your position here?
Thank you, Your Honor. I have two primary questions / concerns. My first question is regarding the judge with whom Your Honor spoke with in California. Judge D'Alessandro has not ever and is not presiding over our case in California. So my question is how it came about that he was the one who conducted the conference and made this determination, because he has not been present at any court proceedings over our case, and he is not presiding over the upcoming hearing on that's later this week.
All right. I note your email that was sent to my assistant back on May the 6th, which specifically identified Judge Samuel D'Alessandro of the Family Law Department. This was from you that informed our court that he was the new judge on the case who would hear it. So naturally, he was the one that this court contacted. I first tried to contact Judge Hamilton, who had handled the case previously, got no response. And then eventually, after receiving your email, the court contacted Judge D'Alessandro, who said that he was bringing himself up to speed in the case. He was looking over the case and apparently did some of that prior to our conference. It was my understanding he was going to be the trial judge. I don't know if it's been reassigned to someone else for the actual conducting of the trial. All I know is it was that judge that I conducted the conference with. So,
Your Honor, that email that I sent you was based on incorrect information that was came from the paralegal at my lawyer's or my attorney's office. To speak very colloquially, the Fresno, California court system, especially the family court system, is a quote unquote mess. They move judges continuously. We have had, I think, 8 different judges hear our case over the course of the last, what would it be, 7 years. And what happened was there's benches by department number, and they moved judges to different departments. So we were previously in department, I think it was 303. Judge Hamilton was the judge presiding in that department. A month or a month and a half ago, they moved Judge Hamilton to a different department, to Department 202. Judge D'Alessandro is now presiding over department, I believe it's 303, which was the previous department. And so the paralegal made the assumption that when the judges were moved, that our case would continue to be presided over in the same department. And so then she notified me and said, you need to let the Kansas judge know that this is a different department, or this is a different judge that will be presiding. Which is why I sent you that email. When I spoke with my lawyer last week, it was, and then followed up with the actual court clerk. I personally called the court clerk in Fresno last week. The courts in Fresno moved our case with the judge. So we are now in a different department, but retain the same judge, which is Judge Hamilton. It will be Judge Hamilton that is presiding over our case. Judge D'Alessandro, I would assume, stated that he was catching himself up with the case because he's never seen it before. Additionally, he's not the judge that will be presiding over the hearing that's coming up this week.
Okay.
So, so he has not ever and will not and will not have anything to do with our case. He has never heard it. He's never seen any of it.
All right. Certainly, if Judge D'Alessandro felt like that he wasn't the one to talk to, I trust he would have told me that. He did clearly acknowledge that prior orders had been entered, I think, by Judge Hamilton.
Mhm.
But he did know that you had been through mediation. He knew that you were scheduled to go to trial this week, and that the case essentially was imminent as far as a trial date was concerned in California. Um, and he asked specifically how far proceedings had gone here in Kansas. And I said, well, until the jurisdictional issue was settled, they haven't been furthered at all, which is the truth.
Mhm.
As I understood it, as I understood the applicable law, California first exercised jurisdiction in the case.
Correct.
They were the court of initial child custody jurisdiction. One of the parties still lives there. Therefore, it would appear under our statutory law that we needed to confer. California needed to make certain findings to send it back to Kansas. That we were the more appropriate forum, for example, that we were the more convenient forum. Those findings were not made.
Here's the procedural brick wall. The judge admits he cannot interpret the California temporary order because the attachment isn't before him. That shuts down both sides instantly. Without the controlling document, no clarification, no enforcement, no advice. Everything pauses until courts coordinate. This confusion is exactly why jurisdiction matters so much.
From the conversation that we had, that's what I based my order on to document in my file that I'd had the conference and that California did not essentially relinquish jurisdiction to Kansas, though I think he certainly considered it. He eventually declined to do so, that it was that court's decision ultimately, not this one's. So rather than set up a situation where you're doing two trials with potentially conflicting orders, I think the laws of the two states are intended to make sure that there's some harmony and some agreement about who's going to exercise jurisdiction, and it appears that California is going to at this point. So one option the court has is simply dismiss this case without prejudice, because I don't know that there's anything right now that the Kansas court can do or will do. But go ahead. I think you're going to make a statement.
I actually I'm just a question. Did Judge Alessandro give a rationale for maintaining jurisdiction? Because I am aware that the California statute requires that children who have not been residents of the state for at least 6 months, and the statute states that children where the predominance of evidence lies is where the jurisdiction should lie. And obviously we have a trial coming up and every single witness is appearing via Zoom from Kansas because all of the evidence regarding the state of the children is here in Kansas. There is no evidence at all in California regarding the state of the children. And so my question is on what basis did California determine that they should rechange jurisdiction? Was it simply because there was a current pending motion, or was there more than that?
I don't want to speak for Judge D'Alessandro and his mental processes for his ultimate decision, though I don't think there's any question that the fact that you've got a trial date actually set and ready to go, that both sides are prepared, both with attorneys, I think that was probably a factor in the decision, without a doubt. Ultimately, it was that court's decision and therefore that court's rationale. So I don't really want to speak for Judge D'Alessandro, but only speak for the fact that the Kansas court is not going to be exercising child custody jurisdiction at this time.
So then my follow-up question is, moving forward, we do have a trial. I have an attorney. He does not actually have an attorney for the upcoming trial. And upon the conclusion of that trial, there will be an order that will exist. I am asking, the current orders, or the orders that were temporarily put in place, require that the children fly to California extensively, and that has a very significant effect on their well-being and their lives. And so that is the basis of the trial. Additionally, it should be known that the children have expressed vehemently that they will not board a plane. I let them know that starting in June, they were going to be required to fly to California per the current orders, or per the temporary orders. And they did express very clearly to me that, short of putting them in handcuffs and having law enforcement take them to the airport, that they would not be traveling to California. Your Honor should know that the oldest is 13, and he is set to testify at this trial as such. Following the determination that the California court makes this week regarding the current orders, and what I am asking California is that visitation continue to be in Kansas, so that the children are able to continue to participate in their regular daily lives here in Kansas, and also maintain a relationship with their dad when he chooses to show up. He was ordered to have visitation in Kansas the months of January, February, March, April, and May. He came January, February, and March, and he has refused to visit the children since then. So there is inconsistency in visitation. There's issues here. The court, I understand fully why the California court retained jurisdiction, because there is the upcoming trial. Following the trial, Judge Hamilton will make a determination regarding custody. For better or for worse, it will be what it is. My question is, following that determination, what process? My children are 11 and 13, so we have 7 more years until, of custody issues. And at what point, or by what process, would it be reasonable for me to bring this case back to Kansas and request another UCCJEA to change jurisdiction? I mean, in my mind, I guess what I'm wondering is, if it's possible, once orders are made, once a determination is made, can we preemptively set up? It doesn't matter what the orders say. To me, it doesn't matter what the orders say. I would like to preemptively set up a follow-up UCCJEA to see about moving jurisdiction here for the remainder. We're not talking like 6 months, we're talking 7 years more of custody. Regardless of whether something is filed a motion is filed to change the parenting time, that it could be established that when it is deemed necessary to make an adjustment to the parenting time order that is going to currently be made now, where that can happen.
To a certain extent, the answer to your question may depend on what the California court does at this trial. Certainly, if the father is granted primary custody of these kids, I can't see a scenario in which Kansas would assert child custody jurisdiction of kids who are under a custody order and living in the state of California. But there are other alternatives that could come out of this hearing that might allow the Kansas courts at some point in the future to assert jurisdiction. However, I'm not in any position to answer your question. Perhaps that would be better addressed to a Kansas lawyer or to your California lawyer,
Okay.
either before, during, or after your trial. I think certainly that lawyer would need to know what the outcome of the California proceeding truly is.
Right.
But what I'm inclined to do at this point is not to dismiss this case at this time. What I'm inclined to do is to leave it open until August the 29th. We have a target in Kansas that civil cases are supposed to be resolved by 1 year. That will be your 1 year from your filing date in this case. I'm just going to grant a stay of proceedings for a period of about 3 more months. We're not going to schedule any more hearings. There's nothing for Kansas to do. Any assertion, a proper or legitimate assertion of Kansas jurisdiction needs to be made by some sort of new motion, depending on whatever it is, enforcement, modification. I don't know what relief would be properly sought. I'm not going to pre-rule on it, but I'll leave the case open for a period of 3 months. If nothing is filed at the end of that 3 month period, in this case, that would properly ask for assertion of Kansas jurisdiction, the court will dismiss this case without prejudice, which means it could be refiled in the future. But I need to get some sort of eventual end to this case, one way or the other.
So then my question would be, in terms of requesting for a reevaluation of jurisdiction, would the request be made here in Kansas? Would the request be made in California? Do I need to do both?
But better asked to lawyers in those respective states.
I will tell you flat out, they don't know. I have contacted 3 separate lawyers in California, and I've contacted 5 separate lawyers in Kansas, and not a single one could give me any definitive guidance, even after paying them their lawyer fees,
Really?
on
Oh, okay.
how to accomplish a UCCJEA jurisdiction change.
Oh, that's interesting.
It was very interesting and actually quite frustrating, which is because I have been trying to get jurisdiction changed since well before he filed the motion. And because I could not ever get a straight answer from any lawyer in any state, in either state, he was able to file this motion he snuck in and filed the motion because he knew I was trying to get it transferred, and I couldn't get any legal help to get it transferred.
Didn't he file his motion in California before you filed your action in Kansas?
I had filed an initial thing, and it was in Sedgwick County, and it was filed incorrectly.
Okay.
I had contacted lawyers here. They didn't know how to do it, and they filed it in Sedgwick County, even though I don't live there, and they filed it incorrectly. And so then when it kicked back, then I had to figure out how to file here. So then I filed here and I filed there. I guess, I mean, it would be very, very surprising. Even the temporary orders still state that the children's primary residence is Butler County. So the location of their residence is not actually what is in contention. It would be the location of the visitation, because the current orders still state that their primary residence is still in Kansas.
Well, is that being challenged in California?
No, it's not.
Okay.
He's not challenging their location of residence. He's actually not challenging anything. The orders state that their primary residence is in Kansas, is in Butler County, and that they are to visit their dad in California. And the only thing that is being challenged is the location of the visitation.
This is
I'm
the pressure point. The judge grants a stay, keeps the Kansas case technically open, and sets a firm deadline. If no proper motion justifies Kansas jurisdiction by August 29th, the case gets dismissed without prejudice. That clock forces action. Either California relinquishes or Kansas steps away entirely.
I am challenging the location for them to be able to, for him to come here to visit them so that they can still do sports, so that they're not missing. Right now, they have them missing 27 days of school a year. I mean, yes, I wish I was kidding. They wrote orders based on a California school calendar, not a Kansas school calendar. It has them missing extensive amounts of school. It has them flying back and forth continually during school. It's just not healthy for them. So the only request, the only thing that's being challenged is I'm saying, please follow a Kansas school schedule for visitation and please have the visitations here so the kids can have jobs and play soccer and have their regular lives. That is the challenge.
Well, it's certainly possible the California court may see it your way. And if so, you'll be comfortable with the California court orders at the end of this trial.
Correct.
That's certainly possible.
Correct.
Um,
I may or may not want to be making I may or may not want to be making a request for a change in the orders, but I do still want to make a request for jurisdiction to lie here so that when the time comes that the orders need to be revisited as the kids get older and what they're involved in changes and all of that, that this court is the court that then subsequently is the one that hears any further issue.
Look,
So,
you should ask the California court for that ruling, it would seem. That
Okay.
if we really want the California court to, at the end of this, relinquish future issues regarding child custody and parenting rights to the state of Kansas, you could ask for the court for that ruling at that point.
so then what I will do is I will prepare an RFO, a request for order, to California for because I did this, but because this motion was already in process, that RFO was denied without prejudice.
Mhm.
She's basically, Judge Hamilton said, see me after the trial.
Mhm.
And also said, maybe you should, actually already had the motion in process in Kansas as well. So I will now refile an RFO and have this revisited. Because this case is already open, then it is my understanding that I don't need to refile an additional motion here.
No, actually you do.
I do.
Where I'm leaving things is that I'm just going to grant a stay. And if you want to properly and appropriately assert Kansas jurisdiction based on post-trial circumstances, you'll need to file a new motion asking the court to do so. There has to be something that takes place between now and August the 29th where there's a proper request that would warrant the proper exercise of Kansas child custody jurisdiction. And it could be based on a California relinquishment at the end of this trial. If so, that needs to be put in the order that they are going to relinquish jurisdiction to Kansas for future proceedings. That it could be very simple. But
Okay.
you will need to do something to prompt reopening, essentially, of this case. It's going to remain open in a technical sense till August 29th. If nothing's filed, we'll review it at that point. If there's nothing filed that would warrant proper jurisdiction of the Kansas courts or bring a new matter before the court that's proper, then the court will just simply dismiss this case. So I think you misled. You are going to have to do something else.
Okay, so I will file motions in both California and Kansas. Judge Hamilton has made it crystal clear that she will not hear anything regarding jurisdiction as part of a custody hearing. She made me even so in the pending custody hearing, I filed all the necessary documentation and declarations to make the request for a change in jurisdiction as part of the current motion, and she refused to hear it and made me file a separate motion for that. Then heard the separate motion and turned around and said, I'm denying this because this other motion still exists. So we will finish with this motion. We'll finish with this motion. Whatever happens, happens. And then I will file both in California and in Kansas a request for a jurisdiction change. Assuming I'm basing that based on the assumption that the children's primary residence remains in Kansas.
Okay. Well, so that once again, just so things are clear, the court will not be entering any orders today other than staying future proceedings in Kansas, leaving the case open until August 29 of 2025 to see if there would be some motion before this court or some new request for relief where we would properly exercise Kansas jurisdiction at that point. So that's where we're going to leave it today, and then we'll see what the outcome is in California, and if you feel that circumstances warrant some request to Kansas to leave this case open even further.
Thank you so much for your
All right.
time. I very much
right.
appreciate it, Your Honor.
All right, very well. Then if there's nothing further at this time, the court will be entering a written order documenting what we've talked about here today. And that will be sent to both parties, obviously. And until then, the court grants a stay until August 29, 2025 for further review by the court to see if the case will stay open. Very well.
Okay.
Then if there's nothing further at this time, we will conclude this Zoom meeting for all participants. This matter comes before the court at this time for further proceedings. I will ask Ms. Bravo first, Monica O'Rourke Bravo. I think you were the one that precipitated the conducting of this hearing. What relief are you seeking?
The hearing process in California came to a conclusion on June 20th. New orders were instated on June 20th of this year. I'm requesting that the new orders be recorded. And also, now that there are no pending cases in California, that jurisdiction again be reviewed with the intent of having the jurisdiction of this case moved to Kansas. The argument for that is that the current new orders, line item 3.02 state, commencing with the date of the signing of this court order, the children shall reside primarily with the mother in Butler County, Kansas. Noting that the children's primary residence and state of residence remains in Butler County, Kansas. And so under the UCCJEA, I am requesting that a subsequent judicial review occur with the intent of change of jurisdiction to Kansas.
All right. Let me address Mr. Bravo Hernandez at this time. Are you opposing the relief that's being sought here?
Absolutely, 100%. We just got done with a court hearing like a week ago or a week and a half ago, and I feel like we're back to square one. The California court did not release jurisdiction. There's a reason why, because they have more background information on the situation, and it is my intention to try to get this move away order removed, and hopefully bring my kids back to California, where they're supposed to be located.
But
I'm not-
wasn't that addressed at this last hearing in June? In the specifics of where the children are living now,
Right.
and where they're going to be seems to have already been submitted to the California court and resolved in essentially the mother's favor. Wouldn't you agree?
Yeah, it was they granted that move away order, but it is my I don't know. I'm gonna try to take any and every route that I can to try to get the California court to somehow remove this move away order, because it was granted under circumstances that should not have been granted. But they did this last court hearing. They did grant me custody in this situation, and I am attempting to gain more custody of my sons. This situation is kind of it has way more background information, and I understand that there's legal proceeding and stuff, but I want to be involved in my son's life, and what my work is attempting to do is cut me out completely. The schedule that she's attempting to push in this situation is just not something that's workable for both of us. Obviously, it is important for a parent to be involved in their son's lives. And what Ms. O'Rourke is trying to do is she's trying to cut me out completely, because as we all know, we all work, and we have employment, and the schedule sometimes is not well, Ms. O'Rourke is proposing is just not something that is good for my schedule, my work schedule, for my life schedule. It's not something that is flexible, and that's something that Ms. O'Rourke should have taken into account when she removed our kids out of the state. And hopefully, the court does not grant her the ability to do that, because she will cut me out completely out of my son's life, and that's what she's been doing the last 6-7 years.
Again, are you suggesting that this court should change the orders that were made in California?
No, I'm proposing that the order that California just granted me to leave those orders and let it stay. And I'm not really sure how. I know the last time you met with a judge here in California, and I think the last situation that I heard was that California would keep jurisdiction of the court hearing, so we wouldn't have to go back and forth through the Kansas and California court. It is kind of stressful to have two different courts dealing with this situation, at the same time.
This court really isn't dealing with it up to this point.
Okay.
This court deferred to the California courts,
Right.
handling the case at the trial level for this hearing that you conducted in June.
Right.
I don't think that it would constitute a permanent relinquishment of child custody jurisdiction, but only for purposes of the fact that we had contested matters potentially pending in two different courts at the same time in different states. California decided to keep jurisdiction for purposes of the trial which just took place, which issues were presented to that court and resolved in some ways against you as the father of the children. And I recognize that you may be dissatisfied with the rulings made by the California court, but
actually in my favor. The last situation was in my favor, and it's been probably about 6 years since I've had a decision in my favor, and so that's why I am in agreement with the California court in terms of the parental situation that they kicked out, because I honestly feel like it's more important for my sons to be around me than mom's been around them for quite a while the last few years.
right. So you think that the California ruling that was made in June is favorable to you?
Absolutely. Compared to actually not the June order, It was like early July, I want to say. Um, Dang, has it been that way? I think it's been like the early July, maybe late June. But yeah, they ruled in my favor to keep the current custody order, which so I have to complete 6 different um, visits out to Kansas, and in August I already scheduled my visit to go see the boys on August the 21st to the 23rd, and then the California court agreed that they should be sent to California during the times that they gave us like 9 different dates or something where the boys will be sent out to California, and we'll both be responsible for covering the cost of those visits.
All right, let me make sure I understand what I'm looking at here. I see an order of child custody and parenting time filed 6/20 of 2025, but the hearing date is listed at 1/15 of 25. Is that not the most recent order that was entered in the California court?
That is the most recent order. The original and temporary orders, this order was put into, I'm sorry, can you hold on just a second? Sorry about that. Someone just like barged into this room. So we had, the original hearing was on January 15th. The orders that are before you were put into temporary place on January 15th. And then a subsequent hearing was had on June 20th to review whether or not the temporary orders would be made permanent. On June 20th, the January 15th orders that were temporary were made permanent. These orders are that the children reside primarily in Kansas and visit California about every other month during the year. I'm not contesting these orders. What Mr. Hernandez is referring to in terms of the move away order was an order that was put in place 2 years ago, 3 years ago now. I think it was almost 3 years ago now. No, 2 years ago now. And that order hasn't been contested and hasn't been revoked. The children continue to reside in Kansas. And as Your Honor said, like, California retained jurisdiction without prejudice during the course of the proceedings from January to June. And because jurisdiction was retained without prejudice, it was made clear to me by the judge in California that at the conclusion of the hearing in California in June, that I would then be, that I needed to re-request the transfer of jurisdiction so that any changes moving forward would be heard by the Kansas court.
The aftermath gets messy. Mother explains California's rotating judges, multiple departments, and why Kansas contacted the wrong judge. The court pushes back. Kansas relied on her own email. This exposes a deeper problem. Fragmented systems create chaos, and procedural missteps can steer outcomes just as much as legal merits.
So the orders that you have in front of you are the current orders. The primary residence of the children remains in Kansas. Under the UCCJEA, I am requesting that jurisdiction be moved as it was. The change of jurisdiction in California was denied without prejudice previously, and it was recommended to me to re-request, and that is what this request is. It is not necessarily a request to change orders in any way. The orders were just instated in California. It is to move the jurisdiction.
And Your Honor, the California court already made a decision on this. Well, the last court, the California court said that they would not release jurisdiction.
Okay, you kind of broke up there. Would you mind repeating what you just said?
Yeah, the California court made a decision on this situation, because she had submitted paperwork to the California court to release jurisdiction. And in California, the judge said that she was not going to release jurisdiction in this situation.
Okay, and where does that say that in the order?
It doesn't say it, but that's what was stated in the court hearing. It is this court thing was put out in January, but we just had a court hearing this last time where Mr. O'Rourke was trying to remove jurisdiction or have the case released, and the judge said no.
Okay. Let me just address Monica for a moment. Was this issue specifically raised at the conclusion of the California court proceedings that were recently held regarding the issue of jurisdiction from that point forward?
There were two separate filings. Mr. Hernandez had filed for a change in custody. The ruling on June 20th was regarding Mr. Hernandez's request for a change in custody. In those custody proceedings, I raised the change of jurisdiction for the UCCJEA. The judge informed me that she would not hear a change of jurisdiction request as part of a custody motion. So in the fall, I think in November or December, I filed a separate motion requesting a change in jurisdiction because the judge at that time said that I had to file it as a separate motion. And then that motion was heard separately. I believe the last hearing for that motion was possibly in December. I'm not sure. I was just as you guys were talking, I was just pulling up the minute order to review. And that motion, change in jurisdiction was denied without prejudice. And just for the sake of Mr. Hernandez, what that means is when a jurisdiction is denied without prejudice, it means that it can be requested again. And she specifically said, I'm not going to allow the jurisdiction to change until the conclusion of this trial. I'm doing this without prejudice with the intent that you are able to, at the conclusion of this hearing, if the children's residence remains in Kansas, to re-request a change in jurisdiction. And I am going to find on my...
That is at least consistent with the discussions that I had with Judge D'Alessandro when this discussion was held regarding the two states possibly having jurisdiction at the same time. That Judge D'Alessandro wanted to see the matter that was essentially teed up for trial in California complete before there was any change in jurisdiction to Kansas. There was never an intention expressed, from my memory, that it would be forever. But certainly it would take us through this trial. And you went to trial, issues were decided by the California court. And of course, then we still have this lingering issue then of what happens from here regarding the issue of child custody jurisdiction. Kansas has a basis for child custody jurisdiction, but so does California. So I would have preferred that jurisdictional issue have been decided as one of the issues reflected by the journal entry, which is attached to the current motion. It doesn't appear to address it.
It does not. The judge in California was very clear that she would not address jurisdiction as part of a custody motion.
So is that set for a separate hearing?
It is not. I am requesting here, as this is their home state, with the intent for a subsequent, as was done before, judicial conference between the courts to determine the issue of jurisdiction change.
Hey, Your Honor.
Yes, sir.
Yeah, I don't, in my opinion, I understand the legality of all this situation, and I understand that Ms. O'Rourke has, possibly has some sort of right to move the jurisdiction of the situation. But I just don't, in the best interest of my children, of our children, I don't think it's in the best interest of our kids to have jurisdiction moved to Kansas. Like I told you before, and I keep on saying this, in a lot of ways, this has been a hijacking move for Ms. O'Rourke to use the legal system to attempt to remove the kids out of my life. And I'm asking for the Kansas court to release this situation and not be involved. Allow the California court to continue to take over the situation or be in control of it, because I feel like the judge that has been involved in this situation, she's more aware of some of the things that have gone on. And I feel like if we move to the Kansas jurisdiction, I feel like this is going to start the situation all over again, and I'm going to be climbing.
And why do you feel that way? I'm not sure I understand. Why do you feel like just simply moving jurisdiction to Kansas and therefore child custody enforcement to Kansas, why that would be adverse to your interests?
Because I like the court, the judge was familiar with the situation, so I feel like starting all over again. Mr. O'Rourke would definitely have a foot above me. I don't know what the Kansas court is like, but I lived in Kansas and I lived in Wichita for about 6 years, and I'm not stating that this would be an issue, but I don't feel like I would get a fair trial in Kansas compared to what I'm getting in California. I feel like the judge here is more. She understands the situation. She has a lot of background, and the California court has a self-help center where I'm able to access that help. I haven't seen anything on the Kansas court system that where I can go and talk to somebody, and so like just having access to that is more helpful for me than having to go through the Kansas court. Like, I'm not in Kansas. If I have to pay for an attorney, that's going to be really impossible for me. I'm already paying child support to Miss O'Rourke. So this is more of a situation where it's going to be hard for me to maneuver legally. And I'm hoping that it doesn't go to the Kansas court, because it just creates all kinds of hurdles for me, to be honest with you.
Well, I'll try not to take offense about your assertion that you believe that you can't get a fair hearing in the state of Kansas.
Well,
I would tend to disagree.
It's not that I'm not going to get a fair hearing. That's probably the inappropriate words to use, but I just don't this in terms of the situation. Mr. O'Rourke is in Kansas and I'm in California. I just don't feel like most people in the Midwest don't see Californians in good standing, and I just don't feel like I have a good. I have like an uphill climb if we go to Kansas first. That's what I'm kind of thinking.
I understand, but I can also understand Monica's position that's been stated all along, that she was granted a move away order by the state of California. She established a new home state for the children here in Kansas, which takes at least 6 months of continued residency. And then once that threshold was met, then she sought relief from the Kansas courts, which to this point, this Kansas court has pretty much denied. After my conference, as I'm required to do under the UCCJEA, I conferred with a California judge in the domestic department in your county and determined that they should complete the trial that was held out there. But that doesn't necessarily mean that it wouldn't be appropriate at some point in the future for Kansas to decide issues regarding Kansas kids. You can assert all you want that they remain California kids forever, but the reality is they live here, They go to school here, and the people that most likely would be able to provide input to this court regarding their welfare are local.
Not,
So I think Monica would certainly be of the point of view that she's not sure that she can get fairness from the state of California, and rather seeks that from this state. And I can understand both of your positions. And I understand your position, sir. All right, Monica, you had something else you wanted to address the court about?
Yeah, I do just want to give this court the information that the assertion that the California court or any particular judge in California has the entirety of the facts of this case is not accurate. We have had 8 different judges hear this case. The current judge that just made this determination, this was the first motion that this particular judge heard in this case. The move away order was granted by Judge Luna. The restraining order was granted by Judge Guerra. There were 2 separate contempt cases. Both contempt cases were heard by 2 separate judges. There was an ex parte hearing that was heard by an additional judge, and in addition to the actual divorce judge. I think that's 8, it may be 7, trying to count. So we have had a different judge for every single motion. The nature of the court in California, and this is what I believe, and I would like to bring the focus back to what is to the kids and who is able to hear what is happening with the kids. Is the reality is that the way the California court is structured, there is never a judge that follows a custody case for all the motions that are involved in that custody case throughout the course of the case. Instead, the structure of it, from what I have experienced and from what I have when I inquired to my lawyer, the way that it works is each different type of case has a different bench. So when there is domestic violence involved, that gets heard over here. When there's just custody, that gets heard over here. When there's an emergency order, that gets heard over here. When contempt charges are filed, it gets heard in a different place. And so there still is not a single judge.
Now the philosophical divide. Father fears Kansas jurisdiction means starting over and losing ground. Mother argues Kansas is where the children's real lives exist. Schools, therapists, coaches, evidence. The judge acknowledges both fears. This isn't favoritism, it's forum selection. Whoever controls jurisdiction controls the future of every custody decision.
That has the facts of this case. And that is part of why I believe it is in the best interest of the kids to have the jurisdiction moved to Kansas, because from what I understand, just talking to people here, is that a judge is assigned to your case, and then that judge hears the case all the way through for any given motion involving the kids. And in that sense, outside of, I believe that Your Honor it would be my assumption that Your Honor would take the time to review some of the previous facts of the case via, supplemental declarations and the motions that were put in front of the court over the course of the last 7 years. Moving forward, I believe it is in the best interest to have a judge continually hear as the children get older, as circumstances change, and as their needs change, be able to continually hear the entirety of what's happening with the kids and be able to have the whole picture. The reality is there's never been a judge. The current judge that made the current orders, this was the first time that she has heard this case as a custody situation like I said, it was Judge Luna did the move away order. This was Judge Hamilton. Judge Guerra did the restraining order. So it's always been separate judges.
How does your proposed parenting plan differ than what the California court ordered?
I do agree with Mr. Hernandez that it is very important for him to have regular interaction with the kids. The primary difference is that I'm requesting that that interaction be in Kansas instead of placing the burden of travel on the kids to go to California. It would allow for Mr. Hernandez to continue to be involved in their lives as they exist here, being able to, like, for example, when he visits here, he's able to take them to soccer games. He's able to participate in their extracurricular activities that they have established here and support them here. And from what I understand, his primary argument for not visiting them in Kansas is not being able to get time off work. And part of my concern with them flying to California regularly is just that he's not able to get time off work. And then that leaves my kids missing out on all of their activities here in Kansas and sitting in California under the care of someone else, not him, missing out on time with him as well. And so if we were able to work with his work schedule and figure out times when he would be able to request time off work so that he would be able to have visits and be involved in the kids' lives that they have very well established here. They play national level club soccer now. So they're very, 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 very involved in soccer. They go to Andover Central. One of them goes to Andover Central, the other one goes to Andover Academy. They're involved in extracurricular activities there and music programs. And I just believe it's very important for him to be involved here. So that would be my primary request. And I understand that, I would assume that Your Honor would want to have more evidence presented. If you were to look at making a change to the California orders, my primary request is not necessarily changing the California orders. My primary and first request is to move jurisdiction here so that we can have a consistent judge be presiding over what's happening to the children for the next 7 years of their lives, so that there is someone that can address their changing needs. And, under the UCCJEA, it says that the jurisdiction should reside in the place where the majority of evidence is, right? So they have family therapists, they have individual therapists here, their school officials, their teachers are here, their coaches, their friends, our neighbors. They have, their world is here primarily. The majority of the evidence for their well-being is here primarily.
All right. Benjamin, you've heard Monica's statements with some reaction, I note.
So we actually just went over this situation in court, and I brought witnesses to trial, and they stood up there and talked how their involvement in my son's lives has been really important. I just will note that none of Monica's family members showed up. It was all my family because my family's been involved in our son's lives. So what Mr. O'Rourke is attempting to do by moving jurisdiction to Kansas and reducing the visits to California, or not having them come out to California at all, is cutting the boys off, not only from me, but it's also cutting off their close relationships with my extended family, which in a way, to me, that is a form of emotional and mental health issues that I can't even imagine what Ben and Sam have gone through the last few years, because they've been taken out of people that are familiar to them and moved to Kansas, to a state where they don't have any family members involved. They have nothing but neighbors and people that are strangers to them. My brothers and sisters watched over Ben and Sam when they were younger, and the California court already went over this, the custody thing, and they determined that it's in the best interest of Ben and Sam to come out to California to continue those relationships with my family, because they have those close relationships. And that, like I said before, Monica is just attempting to reduce my ability to have access to our sons, and that's what she's going to continue to do, because that's she's not looking out for the interest of our boys. If she was looking out for the best interest of our boys, she would not have moved Ben and Sam to Kansas. That was an inappropriate move. I know the California court decided that that was okay, but she declared that her dad was on a deathbed. And when I interviewed him on Zoom, he was picking up his prescriptions from some sort of pharmacy, or admitted to picking up medicine from a pharmacy, driving himself there. So he couldn't be on a deathbed. And I'm not really sure why the California court agreed to give her the move away order. But that's neither here nor there.
Right. Since the order of child custody and parenting time, which issued from the state of California in June, does not appear, and I will review the order again, but I think if it doesn't address specifically relinquishment of California jurisdiction, it will be necessary for this court to once again confer with the judge that actually heard this case, which I think is Judge Jenny Hamilton, correct? Regarding her intentions regarding the retention of jurisdiction, in a similar way that this court conferred with Judge D'Alessandro before the trial. So the court will take any ultimate decision regarding assertion of Kansas jurisdiction under advisement until that conference consistent with the UCCJEA has taken place. I think I will go ahead and set a review hearing date in this case when I have both parties on the meeting.
Your Honor, can you just review what you just said, like just re-explain it? I want to make sure I'm clear and understand what you're.
I'm going to talk to your trial judge in California.
Okay.
And reserve any decision on anything that you're currently moving this court for pending the outcome of that conference.
And it is my understanding from my lawyer that, again, just having kind of giving you some insight into the situation about various benches within the family court system, it is my understanding that Judge Hamilton would not be, like, in any further motions, Judge Hamilton would not be the one hearing that motion. It would be my understanding that, you know, when I had messaged you and I said Judge D'Alessandro is our judge, we would be. It is my understanding that we would go back to the bench where Judge D'Alessandro is, not necessarily return to Judge Hamilton's bench. That she heard that motion for she moved benches in the middle of our hearing. So she continued to finish out our hearing, but is no longer on the same bench that would hear a subsequent custody. So for what it's worth, I would guess, it is my understanding that Judge D'Alessandro is sitting on the bench where we would be at again. But again, just also understanding that there is no consistency in who hears cases in California.
So noted. I have no doubt that if Judge Hamilton believes that she's not the appropriate one to talk to, that judge will inform me of that.
Right. Just, yeah. it's very confusing.
All right. Again, regarding another date to review this case. And as always, my assistant may veto any date that I suggest. But I'm currently looking at August 21. And again, in Central Time, I'm looking at 1:15 for the conference time. Mandy, will that work?
That will work.
1:15, Thursday, August 21. It'll be done by Zoom, similar to today. And I will attempt to get my conferring done between now and then.
Thank you, Your Honor.
August 21, 1:15. Until then, I just want to make sure that it's understood that whatever orders currently exist in the California court are to be followed.
Yes, Your Honor.
All right. And we'll see you in August. Thank you both for your input today.
All right, have a
Thank
good
you,
one.
Your Honor.
If there's nothing further at this time, this matter will currently be in recess. This meeting may be ended for all.
Final word. California's orders remain in force for now. Kansas will conference again with California before deciding whether jurisdiction shifts. Until then, nothing changes. No custody rewrite, no enforcement battle, just waiting. These cases aren't won with emotion, they're won on procedure. Like, comment, share, and subscribe for more shocking courtroom stories.